So you can hear me? Yes, no? Okay. Okay, so my name is still Gabor Gombos, so I haven't progressed too much since yesterday. Welcome to this very, hopefully very interesting session on a quite boring title like legal capacity and less boring like supported decision making. Let me very briefly introduce the session with making some link with this morning and also a little bit of linking with what we did yesterday. This morning we heard about med studies, and as Liz explained us, med studies is, if I understood correctly, generation of knowledge by people who experienced madness, psychosocial disability, whatever name you give to this experience. Now, if you want to generate knowledge, which then will be recognized in the academic community or elsewhere, you need to possess personhood. You need to be recognized as a person who is capable of generating knowledge, which makes sense. Now, if you are seen as mad and you are proud of being mad, and you claim that you are capable of generating knowledge which can be useful for other people as well, and not necessarily only to people who also identify as mad or people with psychosocial disabilities, you are in a difficult situation because all the odds are against the recognition of your claimed knowledge. So we need paradigm and power shift in the field of med studies, as well as in the field of rights of persons with disabilities. What gives this recognition to you as a person in law is what is called legal capacity. Yesterday we spoke pretty much about shifting the power, not only shifting the paradigm. I think agreeably and arguably, one of the worst things you can do to a human being, one of the worst ways you can make the human being powerless is depriving him or her of his or her, of their personhood, full recognized personhood. When I had the privilege to be a member of the United Nations Committee on the Rights of Persons with Disabilities, and I had the privilege to chair a working group which started working on the general comment on legal capacity, I struggled quite a lot. What can law do to make this paradigm and power shift? And what should be done through other measures than law, and whether law is meaningful at all? Our first speaker is Professor Amita Dhanda from India. She is a law professor at the National Academy of Legal Studies and Research in Hyderabad. She was one of the main architects of Article 12 of the CRPD, which is about legal capacity. So we are really privileged to have her on this panel. And she's going to give some answers and insights onto the questions I raise now. Amita, the floor is yours.
Thank you so much. Can I speak from here? How does that? Can you do it on the Alt 4 so that I can also see what the next slide is? Good morning.
Sorry, excuse me. Just use the podium mic.
All right.
Thank you.
Good morning. I have titled my presentation Understanding Legal Capacity, and I've done it with some deliberation. I sort of want to start out by, the reason why I'm saying understanding legal capacity, because I think understanding is something more than us just knowing the provisions of the law. It's also somewhere knowing more than what all can law do. It's about the fact of what are the kinds of things law cannot do, and to work out between the two that what is it that we necessarily need to do with the law and what is it that we may need to do around the law or beyond the law. And my reason for doing this kind of foregrounding is because somewhere since yesterday, in several interventions and presentations, we've had this constant kind of question arising. How much do we need to engage with the law? And if we do, then why and how? I just kind of do a very small thing on telling you what the scheme of my presentation is. The first is about what is Article 12, and that is something that I'm going to spend the least time with, in the sense of that the text of Article 12 and the various ways in which can be read, I will spend a little time, maybe about 2 minutes out of the 15 I have, but it's not, for me, critical to understanding legal capacity. The law ultimately is an expression of a certain number of values and principles. If we don't understand the values and principles and we spend too much time with the text, somewhere in it all, we lose the spirit, as they say, of the law, and we're only left with the form. And I don't want us to do that. And then, of course, I speak about why is Article 12 needed. I'm talking in terms of Article 12 as a removal of barriers. I'm taking off from what we got in yesterday's keynote presentation from Dr. Puras, when he sort of spoke in terms of the global burden of obstacles, and to shift from the global burden of obstacles, to shift to the global burden of obstacles from the global burden of disease. The enabler part of Article 12, and then exactly what are the different tasks and varied agendas. What is Article 12? Very, very quickly. When you are talking in terms of recognizing people's abilities, persons with disabilities as persons before the law, you are primarily acknowledging the fact that there were people with a range of diversity, whether it was psychosocial, neurological, cognitive, emotional, a way of being wired very differently, which was away from what the majoritarian construction of the human mind was, and consequently felt that, no, these people who are so very different can't be people, are better kind of kept outside the law. We've had a fair amount of conversation around the fact of how much of this derecognition has happened in legislations. Large part of it is, of course, happened in legislations, especially in all parts of the world where we had the colonial experience. But even if you did not have an explicit legislation, whether you were seen as a very integral part of the community or not, whether you had customary practices of inclusion or exclusion, I think still hold good and needs to be looked at when we are trying to look at how, what is the personhood that the law is guaranteeing. You can't restrict it only to legislation. You have to be looking at what are the normative practices of a community. So when Article 12.1 is talking in terms of equal recognition before the law, it necessarily is obligated to look at not just legislative practices, but all. The business of recognition of status has also been that you don't just recognize status, you also recognize the capacity to do, and the entire functional disqualifications which subsist in the law have been done away. The article then goes further and says that in exercising your legal capacity, if you need support, you are entitled to seek that support. You can be setting out the parameters by which you are going to be using that, you're going to be exercising, or you're going to be the parameters by which you want that support to be provided to you. And then, of course, the entire set of safeguards against misuse. It's something that you've had spoken to you at several forums. There's a large amount of literature available. There's a fair amount that you have been put into your Dropbox. There's the contribution I've also made in today with other stuff which was there. So I am not wanting us to spend too much time on this. Take it for that this is what Article 12 is providing. My question to you is that, all right, why is Article 12 needed? If it is providing this, but why is it needed? And I think that's wherein this point of that if you do not have Article 12, then there is this whole body of people who cannot be making the contribution that by right. They can make it as a privilege. They could make it because of a certain combination of circumstances where people allow them to do so. They can make it if a community is forward-looking, but they cannot make it if as an entitlement right by the law. More importantly, at any point of time, anybody at all can raise a question on what is happening and say, oh, you are such and such, hence so-and-so law is excluding you, and your contribution cannot be made. And I think that's the point of, it's important to somewhere understand that. So what you are doing with Article 12 is you are rendering that kind of exclusion unlawful. You are saying that, no, you cannot do it because the law doesn't permit you to do so. This is a contradistinction to the fact of that when you exclude without an Article 12, you are doing it because the law permits you to do so. And I think it's extremely important to understand this distinction. It kinds of the bringing of Article 12 creates an obligation to include. You are duty-bound to include people. You can't sort of speak in terms of that you are doing it out of the goodness of your heart. You are doing it because it's that person's right and your duty. I wanted to sort of focus on this Article 12 to remove barriers, and I am connecting my presentation to the presentation that Dr. Puras made yesterday. When I'm saying that, all right, when you speak in terms of Article 12 to remove barriers, you have to firstly comprehend that it will happen in two intensities. One intensity is where new laws allowing for disqualification, permitting substitution, and all should not be enacted, and the committee is on a constant, persistent basis saying that mental health laws which are doing so is against the CRPD and hence not permissible. So that's the first thing that you are doing when you say you are removing barriers. The other is you remove the disqualification from the law. That is from the text of the law or from the practice of the law. If you have a notification, you're just excluding it from there. You are permitting people to use support. Can I have some water? You're permitting people to use support. And you are saying that this permission is something which the law guarantees to you. No, this wouldn't help, Gabor. I just want my glass. So, the moment you're permitted to use support, you are not using that support because of somebody's, again, sufferance. You're doing it because you're entitled to. So if I want to give a power of attorney and say all my financial matters will be handled by such and such, the law would permit me to do so. It is not like it would actually produce the support, but it no longer would be illegal. Nobody can question it. Intensity 2 would be like where you abolish force in the law. you abolish guardianship. Now, evidently, the kind of questions that we've been having since yesterday has been just this, that all right, we get this in the law, so what? We get it in the law doesn't mean that I am going to have all of these supports in fact being available. And if they are in fact not available, what's the great, what's a great game? How useful is it? How beneficial is it? It doesn't really mean too much. And that is the critical thing to appreciate and understand, that the moment the barrier goes away from the law, at least the law is no longer an obstacle to the various other kinds of things that you have to do. And so if you do not remove, on the other hand, the point which a lot of you are raising, which necessarily is that you can write all the fancy words there, how does it matter to me if my life doesn't change? And changing the law is not going to change my life. I agree. Just changing the law, and I would just make this one difference there, just changing the law is not going to change your life. It is true. You require a full range of human diversity, the needs of human diversity to be understood. The kind of stuff that we were having in the previous panel, a large part of the experiential work that people were sharing was to do with awareness raising, was to do with conscientization, was to do with what a community requires, to tell people how much are you missing out when you miss out on such diversity. And that's absolutely required. Similarly, you need to have a range of support needs to be created, support services to be created. You need education and training. You need judges to think differently. You need psychiatrists to any set of professionals who are in interaction with the community, who are setting out services, need to understand that this is to be done in harmony with Article 12. So this is the enabling part. Now, the distinction between the enabling part and the part which is kind of giving out, removing the barriers. What is the difference between the two? The point I want to make with you all is this, that the enabling part is definitely more than the law, and has to be so. But barrier removal, when you speak in terms of obstacles removal, one of the most major obstacles in this business of enabling inclusion and participation is the law. If the law to that extent is not, and I'm only talking in terms of a textual change in the law, if that does not happen, at any point of time, you could have the law stop you in the tracks on what you want to do. So it's obstacle, and one should make this distinction when we are speaking in terms of the law as an enabler and the law as an obstacle, the law as a barrier. I feel the removal of law as a barrier is something which is an absolute necessity. We have no choice in the matter. But to believe that, so we can't really have a continuing law. We can't continue with disqualifying regimes. We need to be sort of, we cannot possibly say that somebody else knows more about your life than you know about it. We create all the support services, but you continue with the support services, the premise that someone else decides for you, you cannot usher in a new kind of era. At the same time, if you just make a change in the law, you believe with the change in the law, just the change in the law has happened for 5 years, 10 years, 15 years, CRPD is 10 years old, and we're still where we are. The fact is that the CRPD has opened conversations like these. It's because of the CRPD that we are sitting and being able to find the space to bargain and negotiate. The CRPD on its own could not bring in the change, but the CRPD was a big facilitator of change. The CRPD gave us that kind of license to be saying that you cannot do an entire conversation around legal capacity without the people who are directly affected by it to be centrally at the table. And I think that conflation is what I am asking you to sort of not to do, to understand Article 12 and legal capacity. So for me, removal of legal obstruction is essential to bring change. Till you have laws by which anybody legitimately and legally can detain you, can decide for you, can proceed on best interest, you cannot, the other initiatives at any point of time can be jeopardized by the law. So as an obstruction, I think it can literally top the list. If you have to speak of some kind of a, like a hit parade, then I think at the top of that hit parade in the obstruction playlist will be the law. On the other hand, removal of legal obstruction is not sufficient to bring change, is an equally important truth that we need to recognize. And I think the second truth is recognized by nearly everybody, and different people have been speaking about it with a lot of vehemence and sharpness and truth. I would have no disagreement whatsoever. I'm only saying this, that in understanding the limitations of the law, don't forget that there is this overpowering authority with the law of determining right and wrong, legality, illegality. And if one has to choose a battle, it's better to be on the right side of the law. Thank you so much.
Thank you very much, Amita. Now we are spending 10 minutes with questions and answers with Amita. And then we will move to Joe and look into a more practical but very essential aspect of legal capacity and supported decision-making. So I think let's start there in the second row. Yes?